supposing a shape which can be protected under designs law can also be registered as a trademark, and if it has a useful configuration, then it can also get a patent. The concern arises as to whether a trader might secure indefinite protection for a useful feature of a product, because it can be protected as a branding aspect. Another area of concern, according to me, is the area of well-known marks. There is a growing tendency amongst the trademark owners to claim a well-known status for their marks. The argument taken is that my mark is famous and therefore it is well-known. Such claims should be adjudicated by the courts cautiously. It is important for the court to identify as to what actually constitutes a well-known mark, and it is imperative to bring about a distinction between the legal and the generic meaning of the term well-known. And further, even where the mark is held to be a well-known, the injury must be shown, as well-known marks get a wider protective umbrella. There should be some caution which should be practiced. Unless an actual injury or harm is indicated to the trademark owner, the protection should not be extended beyond the normal as provided under the Act. You will be drenched to the bone. If your time to you is worth saving, then you better start swimming or you'll sink like a stone. For the times they are changing.
Thank you, Mr. Bhawan. Now I will invite Mr. Ashutosh Mishra to share some words with us.
Good afternoon, all of you. I want to share on benefit sharing of traditional knowledge in the regime of IPR. Basically, Anand sir has already discussed about honeybee and kites. These are the things which are mostly related with the traditional knowledge. First, I want to tell something about traditional knowledge. Traditional knowledge is the knowledge which is created by indigenous people, have some knowledge regarding their environment, management, culture, and other things. But question arises how we can secure the traditional knowledge. It is the main important question arises because so many biopiracies are taking place in today's world. We can see in the area of neem, we can see in haldi, we can see in yoga, and today it is already told about honeybee. It is a kind of new concept, and it is the most important question which is arising in today's world. How we can secure traditional knowledge, because if there is a biopiracy taking place of these traditional knowledge, then it will not only threaten the survival of the so many people, but it will also affect the economy of so many least developed countries also. And I want to conclude this thing because there is a lack of time. We need an international mechanism. We need a strong international mechanism in order to provide, in order to get sustainable development, and in order to provide inclusive growth for the whole society.
Thank you, Mr. Mishra. Now I will invite Ms. Sophie Kejil.
I'm Sophie. I'm doing my PhD on farmers' rights under international law. So today I'm presenting a paper on farmers' rights under PVC legislation, that is plant variety protection legislation in India. First I'll start with the conceptual framework of farmers' rights that is included under the PVC legislation. Before going to it, I think it is very essential to see why we need a specific legislation for farmers in India. So we all know that farmers have been engaged in agriculture from the dawn of civilization. They select and conserve plant varieties in India. Especially when we take the case of India alone. In India, farmers are the major suppliers of both seed and food commodities, and the substantial amount of these requirements are met through farmer exchange. So it is after 1900 when Vigyan rediscovered the plant hybridization, the genetic engineering genetic engineering developed with a high infrastructure investment of developed nations. So the IP framework is such that IP rewards the innovator for his new inventions. So when the developed nations, especially the seed corporates, came up with their new plant varieties, intellectual property rights rewarded them a lot of economic benefits. So they later extended their activities to developing countries where large treasure of traditional knowledge relating to genetic knowledge is located. So in this context, as I already mentioned that in India we know that traditional knowledge relating to genetic diversity is largely located. So they came and without the seed companies came and without the consultation with the farmers and the community people here, they illegally utilized the knowledge and they developed the varieties, and they did not even acknowledge the community of farmers here. So when the extraction or exploitation of developing countries' genetic resource was largely criticized at the international level, the Food and Agriculture Organization set up a commission to study about the concept of farmers' rights. Now, I will deal with the perception that is included under the PVP legislation. The first perception is ownership rights approach. Means the farmers already they contribute towards improvement, development of new varieties. So, intellectual property rights should be the ownership rights should be given to the farmers. The second perception that is evolved is stewardship approach. Means the farmers are the maintainers or conservators of genetic diversity of our country. So they should be prior consulted before we take away their traditional knowledge. The third concept is development rights approach. Means apart from this ownership rights and stewardship rights, the poor farmers should get access to the technology. So the especially the PVP Act provides certain powers on the authority to evolve certain schemes for the farmers to give them access to the seeds, especially the expensive seeds and some credit facility, etc. Now I will deal with the PVP Act, which is the topic for discussion today. There are a lot of favorable factors included under the Act for the farmers. They are in a shorter outlook, they are compulsory licensing provisions and registration procedures for farmers' varieties, and the farmers have the right to claim compensation in case of failure of the plant varieties, and then benefit sharing provision, etc. Now I will go into the major issues that criticism against the Act. The major criticism against the Act is that the Act treats the farmer along with the breeder. Means majority of the examinations research takes place inside the multinational companies, inside the lab of the multinational companies in the case of technologically developed varieties. But in the case of farmers, they always do their experiments in the open field through their manual calculations. So the effort both the parties impart is very different. So the farmers should be given much acknowledgement in this regard. But the PVP Act treats both equally. And the other concern is that the rights over essential derived variety, which are rather made through the technology, rather made through using technology, has given a separate set of procedures to follow for registration. In those procedures, there are no provisions for opposition or examination. That means no third person can go and oppose the registration even if there are sufficient grounds to oppose. And the third concern is that even though there are compensation provisions included in the Act, it is upon the PVP authority to decide what compensation should be given to the farmer. I think it is the basic entitlement of the farmer to negotiate his compensation in this regard. And as I said, the PVP Act also provides innocent infringement in the case of violation takes place. But in this case, the burden of proof lies on the farmer. But in the normal procedure, we know the duty is on the person who alleges violation of his rights. And in the case of the definition of the farmer is also very narrow. It doesn't include the community farmers, community as such. It just say that the cultivator, breeder, etc. So the community aspect is not covered in the definition of the farmer. And even the benefit sharing procedures that are given under the Act is very ambiguous. Means they do not provide any guidelines as to the role of the farmers in the negotiation, and they don't even inform the community or the farmers to what extent their genetic materials have been taken by the MNCs. So obviously this happens. The mightier MNCs can pay very less for billions worth of traditional knowledge through much articulated negotiation. And now there are certain challenges that have come to the farmers, especially free trade agreements that India is entering into, and the sea bill that is right now on the desk of the Parliament. So our law should be much cautious in this regard. Like we should specifically lay down the procedures of benefit sharing, and we should provide incentives for sharing of knowledge among the farmers, which would improve much research and innovation among the farmer community. And to ascertain the ownership rights of farmers, the village or grassroots level, democratic institutions such as panchayat should cooperate to bring forth the varieties in their geographical areas.
Thank you, Mr. Ji. Now I would like to invite Dr. Mohammed Ahmed.
Respected dignitaries and friends, I am going to discuss on the topic geographical indications, a study in Indian perspective. So since we don't have much time, as I have been informed, so a few things I am going to discuss. That is the geographical indications. What is geographical indications? The geographical indications of goods may be defined as that aspect of industrial property which refers to the geographical indications referring to a country to place situated therein as being the country or place or origin of that product, or we can say that the source of that product. So prior to the TRIPS agreement, there was no provision in our country regarding the geographical indications, although in the year 1883 the Paris Convention, which was held at the time when our country was under foreign rule, or we can say that the British India government was there, and our country was not the signatory of that agreement or that convention, and only few countries has participated, and they were the signatories. That's why they were entitled to get the benefits of the convention of article of the year 1883. So after India is after the 1994 TRIPS agreement, India is now obliged to recognize and implement the provisions of national treatment to national of other members, as has been incorporated in TRIPS agreement. Section 3 part 2 articles 22 to 24 of TRIPS agreement deals with the geographical indications. Article 22 of the TRIPS agreement provide for the geographical indications. Geographical indications